Zondi, can you share the screen, please, so that we start?
Yes, Chair.
Good morning, participants. We are ready to start with the webinar. Let me start by apologizing for starting late. As our colleague Nomzamo has said, there was a mix-up with the link that people were used to, were supposed to join with. Maybe let me start by...
You are not waiting so that the glory come upon you. You are hoping you got the glory. It's already in you. That there's more goodness.
I'm not sure what that is. But let me start by wishing everyone a happy Africa Day. As we know, today it's our day as Africans. It's the day on which the Organization of African Unity was formed. So it's appropriate and befitting for us to start the day with good wishes to all of us as we remember this important day in our history. I'd like to apologize for two members. We're supposed to be joined by Advocate Weapon and Ms. Tilly, who have had emergencies this morning and they were unable to join us. So Advocate Strom and I will then proceed with the webinar. You'd know that today marks about 36 days before the enforcement powers of the information regulator come into effect. Can we ask those who are not speaking, please, to mute their audio, because we are getting feedback. We're hearing messages and conversations that are supposed to be private. So it's been a long time coming, preparing for the 1st of July. And I'm hoping that all of us are readying ourselves for that day. So without much ado, I think I will start with the first part of the presentation. But maybe before I do that, I have already introduced myself. My name is Pensi Tlakula. I am the chairperson of the Information Regulator. Maybe I'll ask Advocate Stroman Zama to just switch on the camera to introduce yourself, and Nomzamo, who is head of our communications.
Thank you very much, Chairperson. I would like to also take this opportunity to welcome our participants. My name is Lebogang Zama. I'm one of the members of the regulator.
Nomzamo.
Thank you very much, Chair. I'm Nomzamo Zondi, and I am the Senior Manager Communication at the Information Regulator. Thank you.
Think we can start, then we can start sharing the screen. Nomzamo. And as she's doing that, it has just occurred to me that I did not welcome all of you. A hearty welcome to all the participants who have joined us in this webinar. We appreciate your presence. And also to thank Nomzamo and her team for putting this webinar together. So let's now proceed with the business of the day. Nomzamo.
Yes, Chair, I'll be sharing it soon. I just wanted to put it in PowerPoint mode.
What we have decided to do was to put this webinar together because we were getting a whole lot of requests for webinars on this topic. So we thought that we should just put everyone together. And if people have questions after this webinar, which we might not come to, you can send those questions to us and we'll respond to them in writing. You can send them to Nomzamo, who is the person who has been in contact with you regarding this webinar. We'll start at the beginning for the benefit of those who are attending for the first time with a brief introduction to introduce the regulator, which is established in terms of Section 39 of the Protection of Personal Information Act, which we'll refer to here after as POPIA. And as we know, the regulator is independent and we are not part of the executive. I think we need to stress this because I've seen media reports that say we are an entity of the Department of Justice. We are not an entity of the Department of Justice. We are independent. We report to the National Assembly. The only reason why we are still within the Department of Justice is because they are assisting us to set up, and our policies and systems are still with them. We are using their systems until such time that we are able to develop our own systems. We have our mandate is twofold. We exercise our powers and functions in terms of POPIA, which means that we are authority responsible for regulating the processing of personal information in terms of POPIA, but we are also responsible for PAIA, and we'll talk about that later. Next slide, please. Next slide. The regulator consists of 5 members, myself and 4 ordinary members. You would know that the appointment of the members is a process that is done by the National Assembly. They call on nominations, and that is done by the Portfolio Committee on Justice and Correctional Services in Parliament. They call on nominations, and then they shortlist people from the list of nominees, and they conduct interviews of those that will have been shortlisted, and the names of those that are successful are taken to the National Assembly, which has to approve those names by a simple majority, and thereafter the names are submitted to the President, who then appoints the members for a period of 5 years, which is renewable. We are saying this because the 5 years of the current members is coming to the end, I think around towards the end of this year, around November, December, and the Portfolio Committee on Justice and Correctional Services will be starting the recruitment the process again. 2 ordinary members are full-time, 2 are part-time. 1 full-time member is responsible for POPIA, which is Advocate Weapon, and Advocate Strom, who is here with us, the full-time member responsible for PAIA. Next slide, please. I've already said that our term is coming to an end because the 5 years, we've already served the 5 years. I think for the purpose of those who have not been to any of our webinars, it's important to deal with some definitions because we are going to be dealing with the terms that we are going to be defining in this presentation. The data subject, it's a person to whom personal information belongs or relates. Personal information means information relating to identifiable living natural person. I think it is important to underline the words identifiable living, because personal information of the deceased person is not personal information in terms of our law. And our law is also different from the GDPR, General Data Protection Regulation of Europe, because the definition of personal information includes personal information of an identifiable juristic person, including but not limited to information relating to that person's race, gender, sex, pregnancy, and so on. You can look at the definition in the Act to just look at what personal information, how personal information is defined. Next slide. We also need to deal with a definition of a private body, which is a natural person who carries on or has carried on trade, business, profession, but only in such a capacity, or it's a partnership which carries on or has carried on a trade or a profession or any former or existing juristic person, but not a public body, because a public body has already been defined. So it means a person who processes personal information for domestic purposes only is not a private body for the purpose of this Act. Processing, I think it's important to look at the definition of processing, because it's a very wide definition which is not exhaustive, and it means any operation or activity or any set of operations, whether or not by automatic means, concerning personal information. And if you look at the Act, I don't know, can we go to the next slide, please? If you look at the Act, I think it's important, because I think for the purpose of the slide, we did not include a full give examples of what processing means. It includes the collection, receipt, recording, organization, collating, storage, updating, retrieving, alteration, use, dissemination, transmission, merging, linking, distraction, and so on. All those processes are defined in the Act as a meaning of processing. So the definition is quite wide and it's not exhaustive. Next. Next slide, please. Yes. The regulator has a very wide mandate, and that mandate is provided for in Section 40 of POPIA. And the mandate includes, we have to provide education, we have to educate data subjects and responsible parties on the Act. We have to monitor and enforce compliance. We also have to consult with interested parties on issues relating to the processing of personal information. We can receive and handle complaints and conduct research on any policy or on proposed legislation that affects the processing of personal information, and we report to Parliament for the mandate for the activities that we conduct. We can issue, amend, or revoke codes of conduct. We'll talk about this. We can make guidelines to assist bodies to develop or apply for codes of conduct, and we can also facilitate cross-border cooperation in the enforcement of privacy laws, which means that anyone who wants to send information, personal information across borders, have to comply with certain requirements that are provided for in the law. I'm not show what is going on here with the next slide. Ms. Zondi, yeah. Can you go back to the previous slide, please? Ms. Zondi.
I apologize, there's a slow pace in the response of my slides. Apologies for that.
I can't hear you. Okay, I don't know what is going on. So what is the purpose of the Act? The purpose of the Act is provided for in Section 2 of POPIA, and the Act gives effect to the constitutional right to privacy by providing the way in which personal information, or anybody who processes personal information, it provides conditions for that. But I think the Act also provides that in giving effect to the right to privacy, it is important to balance the right to privacy against other rights, such as the right of access to information and protecting the free flow of information within the Republic and across international borders. So this is important to emphasize that the right to privacy, as provided for in this Act, it's not an absolute right. It is subject to justifiable limitations. So the Act also, meaning POPIA, regulates the manner in which personal information must be processed, and it does that by establishing the 8 conditions for the processing of personal information. These conditions must be in harmony with international standard, and they prescribe a minimum threshold requirements for the processing of personal information by anyone or a responsible party who processes personal information. The Act also provides persons whose personal information is processed contrary to the law, rights and remedies. So this speaks to our mandate of handling complaints, which means that any data subject who feels that his or her personal information was processed unlawfully, they can then approach the regulator, and the regulator will provide, after investigation, that data subjects with remedies. And the Act also, of course, establishes the information regulator. And the application of POPIA. POPIA applies to the processing of personal information entered into a record for or by a responsible party through automated or non-automated means, provided that when recorded personal information is processed by non-automated means, it forms part of a filing system. And it is important to point out that POPIA takes precedence over all other laws that regulate the processing of personal information if those laws provide less protection than POPIA. I think this is important because we've been having a to and fro with the National Consumer Commission as to which act gives precedence, which one has primacy between POPIA and the National Consumer Act. We have not reached an agreement on those issues. We feel that insofar as direct marketing is concerned, especially direct marketing through electronic, unsolicited electronic communication, we feel that POPIA provides in some instances more protection than the National Consumer Act, and we are of the opinion that in those instances, POPIA should trumps the National Consumer Act. That's a debate for another day. We will not enter into the debate today for the purpose of this webinar. Of course, POPIA does not prevent a public body or a private body from exercising its powers. It's important to stress this because we have heard people saying that the introduction of POPIA is going to make it difficult for people to conduct their businesses. We have heard also where people say that POPIA stifles innovation. I think POPIA can exist side by side with all those instances. We have already said that on the 1st of July, all responsible parties must ensure that the processing of personal information complies with POPIA, and the enforcement powers will come into effect on that day. People are asking us, is the 1st of July going to be the deadline? Is it going to be extended? We have to say here unequivocally that that deadline is not going to be extended, because we have had quite a long period of time to ensure compliance. You'll recall that the Act came into effect, or it was adopted by Parliament in 2013. In 2014, only certain sections were brought into effect, and others were brought into effect, as you know, last year. So I think we have had a reasonable amount of time to ensure preparation. We are mindful, though, of the fact that this is a complicated piece of legislation that will be applicable for the first time in our country. We are mindful of that as we go into the 1st of July 2021. And on the 30th of June this year, we'll also be responsible for PAIA. You know that at the moment, the PAIA is with the South African Human Rights Commission. So on the 30th of June this year, we'll take over that function. Next slide, please. And on the 1st of July as well, Section 58 of PAIA, and this is the section that talks about obtaining prior authorization from the regulator when a responsible party processes types of information mentioned in Section 57. So that Section 58 will come into operation on the 1st of July 2021. You'd recall that in 2018, I think it was, we adopted and published regulations in terms of Section 112 of POPIA, 1122. The regulations were adopted, they were published in the Government Gazette, but they were not brought into operation. It's important to mention that some of those regulations, particularly Regulation 4, which deals, let me start with Regulation 5, that deals with applications for Code of Conduct. That regulation came into operation, I think, on the 1st of March 2021. The regulation number 4, which deals with registration of information officers, came into effect on the 1st of May this year. The rest of the regulations will come into effect on the 1st of July. We have already defined a data subject. We have defined, I think we have not defined a responsible party, which is a public or private body or any other person which alone or in conjunction with others determine the purpose and means for processing personal information. So any person who processes personal information or determines the means for processing is a responsible party. And then operator is a person who processes personal information on behalf of a responsible party, but does so in terms of a contract or mandate which that operator will have been given by the responsible party. And a competent person is a person who is legally competent to consent to the processing of his or her personal information in respect of a child, a guardian of that child or a parent will be a competent person. Next. The Act then provides for 8 conditions for the processing of personal information, which means that when we talk about compliance with the Act, it means that responsible parties have to ensure that they put processes and mechanisms in place to comply with each and every one of these conditions for the lawful processing of personal information. Having said that, we can look at each of those conditions in the next slide. The first one is accountability, which means simply that the responsible party has to ensure that they are accountable by ensuring that they comply with these 8 conditions for the processing of personal information. And then there is the condition of processing limitation, which means that personal information must be processed lawfully in a reasonable manner.
The mistake of falling in love with the one you're getting under to get over another. Bye.
Can we please, once again, I'm making an appeal to ensure that we mute our mics. So in a reasonable manner, which does not infringe on the privacy of a data subject, and processing must be minimal, must be adequate, must be relevant and not excessive, which means that when a responsible party processes personal information, they have to ensure that they only collect the minimal personal information that they need for the purpose for which they are processing that personal information. I always give an example of gated communities or even office blocks, although they are private properties. But we all know that when we go into some office blocks, they collect a lot of personal information. They collect our names and our surnames. They scan the discs of our cars. They scan the license as well. And you know that as soon as you scan the disc and the license, then you are collecting a lot of personal information about the data subject, including their addresses, their IDs, and so on. And although we are still looking at this question, but I think that that constitutes excessive processing of personal information, because for the purpose, for security purposes of entering a complex, I don't know why people would want my ID, they would want all the information that they collect. It's one sector I think that we have to look at, but I'm giving this as an example of minimality. And the personal information must be processed with the consent of the data subject or a competent person, which means that if it is a personal information of a child, then it has to be collected with the consent of the parent or guardian. And the data subject must have the opportunity to object to the processing of that personal information, and the information must be collected directly from the data subject. It is important to note that under each and every one of these conditions, there are exceptions. So as you read the conditions in the Act, you also have to ensure that you look at the exceptions. And then the next one is purpose specification. The personal information must be collected for a specific purpose, and it must be retained, but not for a period longer than the initial purpose. So if, for instance, I enter into a contract with Vodacom for the purpose of them providing mobile phone services to me, I give them my personal information. They must retain it for as long as I remain their customer. After that, they have to delete that information. Of course, that will be subject to applicable laws which regulate the period of retention of personal information. And then, of course, as I've said, there are exemptions to this rule. As you can see, then further processing, it means that if personal information was collected for a specific purpose, further processing of that personal information must be compatible with the purpose for which the information was initially obtained. And further processing as well has to be done with the consent of the data subject. And of course, as I've indicated, there are exceptions to this condition. For instance, further processing which is done for the purpose of maintenance law, further processing by the police, for instance, for research, historical purposes, that those constitute an exemption to this condition as it is stated in the law. But even if it's an exemption, the personal information still has to be secured. The personal information must be complete. In fact, for further processing, maybe an example that we can give, and it's what is current now, is the whole debacle of WhatsApp. As we know, most of us are or were customers of WhatsApp. And you know their terms and conditions, their privacy policy, which they were supposed to introduce on the 15th of May. I don't know whether they introduced it or not, or they have pushed that back because of the outcry. But in terms of that, they've collected our personal information for the purpose of providing us with their services. They're now introducing a new privacy policy, in terms of which they will further process our personal information by sharing it without our consent with their companies, such as Facebook, for instance, because Facebook, as you know, owns WhatsApp. So they've introduced that constitutes further processing, and further processing can only be done with the consent of the data subject. What they have introduced in the new privacy policy in terms of service is what we call, it's not voluntary consent, because they sort of wanting you to consent, or you either consent. If you don't consent, you must then they board you off their platform. That can never be consent because it is not obtained voluntarily. Of course, this is a matter that we are pursuing with Facebook. We have taken a decision that we need to pursue that issue quite rigorously, because we don't feel that because a responsible party is a giant as Facebook is a conglomerate, then they can do as they wish with our personal information. That is why, even if we are a tiny entity compared to who they are, but we think that we should do as much as possible to protect the South African users. Information quality, of course, personal information must be, which is collected, the responsible party must ensure that the information is complete, it's accurate, it's not misleading, and it's updated. And openness means that the responsible party must maintain records, and they must notify the data subject when they collect their personal information. Next, please. Next slide. Next slide, please. This one is the important one. The responsible party has to ensure that they secure the integrity and confidentiality of the personal information that they process. They must ensure that they put reasonable and adequate technical and organizational measures to secure that personal information. Of course, at this point in time, people are asking us what the meaning of reasonable and adequate is, and it's something that we are working on so as to guide everyone on the meaning of reasonable and adequate security safeguards. And if personal information will be processed by an operator on behalf of the responsible party, the operator has to ensure that they also put reasonable and adequate security safeguards to protect that personal information, which they are processing on behalf of the responsible party. And information must be treated as confidential, and if at all a breach occurs, if that personal information is unlawfully accessed by someone who does not have authority to access that information, the responsible party will then have to notify the regulator of the breach. They will also have to inform the data subject, the owner of the personal information, about the breach. And we know that this has happened. I mean, there are so many data breaches in this country. I think we are going towards 100 just in this financial year. Apart from those that you might have read about in the media, there are others that we become aware of through the notifications that we get from the responsible parties. And then data participation, which means that a data subject must have access to the personal information. He must be informed if he can approach the responsible party to find out whether they are holding his or her personal information. They can do that free of charge, and they can also ask for the correction or deletion of their personal information if it is inaccurate, incomplete, irrelevant. And they can, as I've said, they can access that personal information free of charge. Next slide. So, what is it that public bodies and private bodies must do in preparation for the 1st of July? Or I'm hoping that that's what you have been doing. You have to put systems and processes in place to ensure that they comply with these 8 conditions for the lawful processing of personal information. Next. And what is it that they need to do? I think we are just guiding to say what responsible parties have to do include the following. They must assess all the personal information in their possession. I mean, if we are the information regulator, for instance, by assessing the personal, we're holding the personal information of the employees, the members of the regulator, personal information of people who have applied for jobs. They send us their CVs, personal information of responsible parties who have to comply. We also have personal information of the service providers, people who provide us with service. So we have to audit processes that we use to process that personal information. How do we process it? To collect, through collection, where do we store it? How do we store it? And so on. And then we have to ensure that we put safeguards in place, security safeguards in place to protect the integrity and confidentiality of the personal information that we have in our possession as a responsible party, in this case, the information regulator. And we also have to appoint information and deputy information officers where this is required and register them with the information regulator. These are some of the things that you have to do to ensure that come the 1st of July, you are compliant. I will then end here and hand over to my colleague, Advocate Stroom. Thank you.
Thank you very much, Chairperson. I will continue the rest of the presentation until the end. I'll cover issues of information officers, deputy information officers, complaints, our enforcement mechanism, and then I'll conclude. Both POPIA in terms of Section 36 require that each public and private body an information officer and to designate and delegate a deputy information. The regulator has developed a portal for the reception of information.
Advocate Strum, you're not
audible. Can you hear me?
No, not really.
Can you think?
Yeah, your line,
Can
I
you
think.
Hear me?
Yeah, you are breaking very badly. We can hear you. Your line is breaking.
Yeah. Can you hear me? Am I audible now?
Maybe rejoin. Line is very, very bad.
It's very bad.
Advocate Strum, maybe keep your camera off so that maybe the reception will be better. Okay, we apologize for that poor connection. Advocate Strum has logged off and should be rejoining the meeting again. Apologies for that.
Can you hear me now? Hello?
Yes, it's much better.
It's much better. Thank you very much. I think my Wi-Fi is down or something, but let me proceed quickly. I was dealing with the issue of information officers and deputy information officers, and I was at a point where I said the regulator has developed a portal for the registration of information officers and deputy information officers. The portal, it went live, and we are aware of the challenges. Some of our the information officers of the DIO couldn't register. Some halfway through the registration process, they couldn't proceed. And we find the challenges for also an information officer or more than one company properly register all companies that they are information of. So we are aware of the challenges, and we apologize for the challenges. We are having continual meetings with the Department of Justice and Constitutional Development, and they are using this portal for us to enhance the portal, but it will be a fixed in due course. Next slide, please. Can I have the next slide, please? Yeah. The duties and risk information includes the following: the encouragement of compliance with the conditions for the lawful process of personal information, which the chairman has spoken to, the 8 conditions, the dealing with requests to the public body pursuant to POPIA, with the regulator in relation to investigations conducted pursuant to Chapter 6. Chapter 6 deals with prior authorization in relation to the body. Next slide. Some of the duties include ensuring compliance, body with the provision of POPIA, and as may be prescribed. And you know that when you say prescribed,
I don't know whether you can move, but your line is very bad.
My Wi-Fi is down, so I don't know. I've been trying to move. Am I audible?
Maybe I should take over because I think it's a problem.
Okay. Okay.
I think I'll take over from there. I'll also switch off my camera for the purpose of improving the quality of the sound. I hope you can hear me. The information officers must ensure compliance by the body with the provisions of POPIA. And if you look at our regulations as well, we have prescribed further functions of the information officers, and you will find this, I think, in Regulation 5 or 4 of the regulations, either 4 or 5. And as Advocate Strom has said, the information officers can only take up their duties after they have registered with the information regulator. I think there is something that we need to clarify here. You will recall that under PAIA, there are existing information officers. Those same information officers will be information officers who will be responsible for POPIA. So as soon as they can never perform their functions under POPIA until they have been registered with the information with the information regulator. We are stating this because we have received queries about this issue. Yes, those PAIA information officers can continue, should continue to perform their duties, but as soon as they perform their duties under POPIA, they then have to register. And as we know that each public and private body must designate a number of persons, if any, as deputy information officers to perform the duties that are stipulated in Section 51 of POPIA, or they should perform any duty imposed or conferred on the information officer by POPIA. So I think what is important here on the designation and delegation is the words, if any. We have been asked whether each information officer is it compulsory for an information officer to designate and delegate their powers to the deputy information officer, but the Act is very clear. It says that they can designate any such number of persons, if any, if they want to do that. Let's go to the next slide. Next slide, please. We were talking about a designation of information officers and appointment of information officers. Advocate Strom's line was quite bad, but she spoke a bit about the portal through which responsible parties should register their information and deputy information officers. You will know that we are still using the systems of the Department of Justice, and the system that they developed, the portal, had some issues. We are fixing, we are attending to those issues, but the registration is continuing. Some of you might have experienced, we got a lot of people, I think when they panicked, they decided to send us their application forms through email, and we are aware that you also encountered problems with the space of the email because the emails were bouncing back, and we then requested the Department of Justice to increase the space in the emails. I'm hoping that those emails are not bouncing back, but because you are our partners, we also really appeal to you, should you encounter any problem with any of our processes and systems, please make us aware so that we can deal with those problems. So know that we are also implementing this Act for the first time, and it is anticipated that as we implement, there will be teething problems which we then have to fix going forward. And then there's the issue of transborder information flows. That is in section 72 of POPIA, which states that a responsible party in South Africa may not transfer personal information of a data subject or a third party to a foreign country unless that third party, the country which receives the information, has a law or binding corporate rules or a binding agreement which renders adequate level of protection. So it means that if any public or private body wants to transfer information across the borders of this country, will then have to ensure that the country has adequate laws or binding corporate rules for the protection of personal information. The enforcement powers of the regulator that are coming into effect on the 1st of July. I think it's important to point out that the following constitute interference with protection of personal information of a data subject. So breach of any of the conditions for the lawful processing of personal information constitutes interference with the protection of personal information and attracts certain penalties. We talked about the 8 conditions for the processing of personal information. And also, there are certain sections in the Act which also attract sanctions if failure to comply with Section 22, which talks about the responsible party notifying the regulator and the data subject where there has been a security compromise. Non-compliance with that, also it's an offense. Non-compliance with Section 54, of course, this deals with duty of confidentiality. We won't go much into that. And then non-compliance with Section 69, which is direct marketing by means of unsolicited direct marketing. That is in Section 69, 70, and 71. Failure to comply with those sections also attract a sanction. Failure to comply with Section 72, which I have just spoken about, which is transfer of personal information outside the borders of the Republic of South Africa, also constitutes an offense. And any person who feels aggrieved and who feels that his or her personal information was not processed in compliance with the provisions of POPIA, if they feel that any of those 8 conditions were not complied with, then that person can submit a complaint to the regulator. You must remember that those 8 conditions, there has to be compliance with each and every one of them. So if a complainant feels that their personal information was processed not in compliance with any of those conditions, then they can lodge a complaint. A responsible party or a data subject may submit a complaint in a prescribed manner or form. Also, if they are aggrieved by the termination of an adjudicator after investigating a complaint relating to a breach of an approved code of conduct. I have to say a little bit more about this. You know that POPIA provides in section, I think it's section 60, from section 60, that the regulator can issue a code of conduct on its own initiative, or it can issue a code of conduct by application, on application by a relevant body, which means that any specified body or class of bodies, any specified industry, profession, vocation, or class of vocations, and so they can apply to the regulator for issuing a code of conduct. What we have done as the regulator, as you might be aware, we issued guidelines for issuing of codes of conduct Those guidelines have been published in our website. They've also been gazetted. So any specified industry, profession, or industry or vocation which wants to apply for a code of conduct, they must ensure that they do so in the manner prescribed in the regulations. They should also follow all the steps that are in the guidelines. What we have also issued is a prescribed standard for dealing with complaints. For instance, if a body that applies for a code provides in that code for a process for handling complaints, then that process for handling complaints must comply with that specified standard that we have issued, and that specified standard you'll find in our website. So the specified standard for dealing with complaints also provides that if a body then handles its own complaints, they must also ensure that they appoint an adjudicator who will handle the complaints on behalf of that responsible party. So if there is provision for if there is a process for handling complaints, that process must also ensure that there is an adjudicator who will be appointed by the responsible party, by a body who will handle complaints. So any data subject or any responsible party who is aggrieved by the determination of that adjudicator can then submit a complaint to the regulator. I wanted to explain that because what you see on the slides is not completely, just says that anyone can submit a complaint against the determination of the adjudicator. So I needed to explain to you how the adjudicator comes into the picture. When we received a complaint, we can conduct a pre-investigation. We can act as a conciliator where this is appropriate. We can decide to take no action. We can conduct a full investigation. We can refer the complaint to the enforcement committee. The enforcement committee, next slide, is made up of, it's going to be chaired by a judge. We are looking for a retired judge. It will also consist of one member of the regulator. It will consist of 3 other people, and will be issuing an advert to set up a what is it? We'll be inviting people to apply for serving on the panel. I wanted the word panel of of experts who will sit on the enforcement committee with us. Next slide, please, or the previous one. I'm not sure. Maybe I skipped. The enforcement committee will consider all. In fact, there was a slide that talks about the powers of the regulator when we investigate a complaint. We have all the powers that are similar to that of a court of law. Can summon people to appear before us, administer an oath. We can enter and search premises, of course, with a warrant, and with a warrant we can search and seize equipment and material which is relevant for the purpose of our investigation. Can we go back to that slide of we have dealt with this? The functions of the enforcement committee, it must consider all the matters referred to it in terms of POPIA and PAIA and make a finding. I think it's important to stress that in the past, now as it is before the 30th of June, you'd know that responsible parties or private and public bodies, let me use that, have ignored the South African Human Rights Commission when it comes to issues relating to PAIA. Those days are coming to an end because non-compliance with a request for information after the exhaustion of internal remedies that non-compliance will come to POPIA, it will come to the regulator, and it will attract sanctions as well. The enforcement committee makes recommendations to the regulator in terms of steps that must be taken relating to the complaint. I think you can look at this because we are running out of time. Let's look at the next slides, please. You can look at the powers of the enforcement committee. They can issue, let's start with the enforcement notice, I think, because that is important. Just go back a bit. Go back a bit. The regulator, after considering the recommendations of the enforcement committee, if it is satisfied that the responsible party has interfered with the protection of personal information of a data subject, it might serve that responsible party with an enforcement notice. That enforcement notice can require the responsible party to do one of the following: can request the responsible party to take steps specified within the period in the notice, or refrain from taking such steps. So it can also, the enforcement notice can also compel the notice in the enforcement notice can also compel the responsible party from to stop processing personal information in the manner specified in the notice, or to stop processing personal information for a purpose or a manner specified in the notice within the periods specified therein. Of course, once an enforcement notice has been issued, the responsible party may apply in writing to the regulator for the cancellation or variation of the enforcement notice. If the responsible party does not agree with the decision to issue that enforcement notice, they may lodge an appeal in the High Court for setting aside or varying that enforcement notice. I think it's important here to stress that the enforcement notice, the setting aside thereof, is not through a review process. It's through an appeal process, which means that that enforcement notice remains binding until it has been set aside or varied by a court of law. And a complainant who is not satisfied with the decision of the regulator not to take any action or to cancel or vary an enforcement notice may also appeal to the High Court. Next slide, please. And a data subject or the regulator, at the request of a data subject, may also institute civil action for damages in a court of law. So I think it's important to say that if a responsible party has interfered with the protection of personal information of a data subject in terms of Section 73 of the Act, either intentionally or through negligence, then the regulator can then take action on behalf of that data subject for damages, or the data subject may do that himself or herself. So it's important that even for data subjects, if we feel that there has been a systemic non-compliance, nothing prevents, by a particular responsible party, nothing prevents the responsible of the regulator from taking civil action for damages against the data subjects, or on behalf of data subjects, I beg your pardon. And then there are certain provisions of POPIA that attracts sanctions, criminal sanctions. So anyone who contravenes Section 100 to 106 commits an offense, and contravention of certain sections attracts a heavier sentence than others. For example, failure to comply with an enforcement notice that I have just referred to attracts a fine of up to 10 million or imprisonment for a period not exceeding 10 years or both. And there are contravention of certain sections that attracts a lighter sentence, and we have stipulated that, and that can be about 12 months, but the regulator may cause to be delivered an infringement notice on any responsible party who is alleged to have committed an offense. So if you've committed an offense, and this is what the infringement notice can state, it will state the name of and address of the infringer, who will be a responsible party, the particular offense that that infringer has committed, the amount of an administrative fine not exceeding 10 million, which is applicable. Of course, this amount can be adjusted by the Minister of Justice, taking into consideration a consumer price index. Next slide. Next slide, please. The infringer may elect to pay a fine of 10 million, or they may elect to be prosecuted. And that fine of 10 million will be paid into the National Revenue Fund. Next. I think before I conclude, because I mean, we asking everybody to comply, because non-compliance does not only attract those fines that we have spoken about and period of imprisonment, but I think non-compliance also constitutes a huge reputational risk for a responsible party. I think in conclusion, I also have to inform you that as we go forward and marching towards 1st of July 2021, look at our website. We have posted on our website a number of guidelines that we have developed. The guidelines on the development of codes of conduct, which I've referred to, which will assist bodies who want to apply for their code of conduct. Of course, we have already received applications for codes of conduct. We have also published a guidance note on the application for prior authorization to guide responsible parties who intend to apply for prior authorization for the processing of personal information provided for in Section 57 of POPIA. We have received a large number of applications for prior authorization. We are looking into that. In some instances, we feel that people have applied for prior authorization to process certain kinds of information, even if it was not necessary for them to do that. I suspect that they submitted those applications just to ensure that they are on the right side of POPIA. We have also published the guidance note on information and deputy information officers, and people have self-registered on our on the portal that we have developed. There are certain guidelines, guidance notes that we are also going to be publishing soon. One of those will be the guidance note for applying for exemptions from a condition for the processing of personal information, or exemptions which a body can on its own decide and say, look, we are this kind of body, and we therefore feel that we should be exempted from complying with the provisions of POPIA. And the exemptions are provided for in section, I think it's 36 to 38, and we are at the tail end of finalizing the guidance notes on exemptions from the conditions for processing of personal information. We are also looking at the guidance note on direct marketing, which I know that I saw that Dimasa is on the line. We did inform you that we will be issuing that guidance note as well. So there will be a number of guidance notes. Some of them we will issue before the 1st of July, but others will issue as we go ahead. So I think we should stop here, and we'll take questions. I hope Advocate Strom will be able to join me so that together we can deal with the questions that will be asked. Thank you very much for your attention, and apologies for all the glitches. I think, Nomzamo, you can take questions. I think you can.
Yes, Chair. Yes, Chair, we do have a hand up. We will take some questions from the floor, and then if time allowing, we will also look at some of the questions that are posed in the chat group. So we do have a question from Andrea de Jong. Andrea, please unmute yourself and ask your question.
Thank you very much for the opportunity. Just want to confirm, unfortunately, Advocate Stroom's line's quality was very poor when I think she was addressing this point. A lot of our clients and ourselves, we were trying to register information officers on the portal, and some of the groups have chosen the same individual to register as the information officer on the various subsidiaries, and they were blocked given that it's the same individual with the same identity number registering as such. Is that a system fault as raised earlier as a system problem that you're attending to with your partner, the Department of Justice, or is this the intention of the information regulator that one person cannot serve as the information officer for more than one subsidiary or for more than one responsible party? Thank you.
Yeah, no, it's not a systems glitch. It is intentional. If you read the guidance note, we actually make it very clear that if you have a holding company with its subsidiaries, then obviously in a subsidiary you have an MD or you have a CEO. So the MD or CEO of that subsidiary, of each subsidiary, becomes the information officer. Of course, we have come across a situation where one company has a number of subsidiaries, but the person says to us, he's the only one in the holding company who can be an information officer. We find that quite interesting, because we are saying that if you look at the guidance note, if there is an information officer, he can also authorize certain persons, other persons, to act on his or her behalf as information officer. But to answer your question, it's not a system glitch in terms of the guidance note, how we framed it. It's one person has to be a responsible party for one organization. So we find, of course, as I say, that like any other system, as you implement it, you will discover things that don't fit into the mold, and we will deal with that. Like that, where one person has come to us to say, look, we have a company, a holding company with 5 subsidiaries, but there is no one who is full-time in these subsidiaries because those companies are simply funds, you know. So we'll deal with that. But the rule is that there has to be, if it's a holding company, the CEO of that holding company is the information officer who must be registered. And the head of its subsidiary must be a registered information officer for that subsidiary.
Ma'am, what do you do if the compliance officer is employed in the holding company and key performance areas is to caretake the compliance duties for all the subsidiaries within the group? Then she's an employee of the holding company, but her key performance areas is to caretake all the subsidiaries within the group. Then,
well, as I've indicated, those were not situations that we had envisaged. So where there are anomalies within, you know, the system that we had envisaged, obviously we'll have to deal with those. I think on a one-to-one basis, if there are exceptions within the general rule, but we never envisaged what you are talking about when we developed the guidance notes. So it's something that we will have to look at.
Thank you.
Okay. And then should we raise that individually then with the regulator per email with cover notes? And then we should raise that individually with the information with yourself, with the cover notes explaining the situation.
You have to
register on.
Yeah. I think you have to write to us first because we've already received correspondence. Please direct your query to Mr. Nemasisi. Write to him.
Thank you.
Yeah, do that, please. Thank you.
Thank you, Chair. We will share Mr. Nemasisi's email address. We have 2 hands from Audrey Catherine and Karabo Nemakonde, so I'll just ask them to follow each other. Audrey, you can go first. Thanks.
Yeah, no, sorry. I was just on the same note that Andrea spoke of. What if there are 2 different companies that have nothing to do with each other? What if bar for the fact that the MD is the same person? So one person owns 2 different companies that do 2 different things within the market. So essentially, according to PIA, the noted MD is the information officer. So how do you register one person that is the MD for 2 separate companies that are not subsidiaries of each other?
Yeah, I thought I also indicated that the guidance note says the MD can authorize another person to act as an information officer, isn't it? So
yes, I get that, but due to the size, so in terms of impact, it's big, but in terms of people within each company, it's very, very small. So it kind of doesn't make sense to take on a deputy information officer, and regardless, the information officer still needs to be registered because you have to register Peanut A as the information officer and Peanut B as the deputy information officer, because who does the deputy report to?
But are you saying that I mean, it's going to be very difficult for me in this webinar to deal with each unique situation of each company. But are you saying that in that company, you have Mr. X, who is responsible, who's the MD for both company A and B?
Yes.
He's the information officer. He's supposed to be the information officer in both A and B. Is there nobody else in B that he can authorize? He can't authorize anyone in B to be the information officer?
Not necessarily, because he can authorize to be a deputy, but the point still remains that he would still, when it comes to should the pawpaw strike the fan, the regulator will be going to the information officer, not the deputy.
No, forget about the deputy. I'm not talking about the deputy. Deputy is designation and is delegation of power. There are 2 things in the guidance note. The guidance note talks about the information officer authorizing another person to act as an information officer. In addition to that, there's a clause on delegation, and the delegation is the delegation from the information officer to the deputy information officer. So,
okay.
Yeah.
Okay, so in that instance then, okay, where the information officer is authorizing another individual to act as information officer, who then would the liability rest with? The person receiving the authorization, or still the named MD on the business papers?
In my view, if they have authorized another person to act as an information officer, the person who is authorized as such is the one who carries the responsibility. In my view, authorization is different from delegation, because when you delegate, a person who delegates retains the accountability. But if he authorizes another person to act as an information officer, the authorized information officer will take all the responsibilities and the obligations.
Thank you, Chair.
All right, perfect. Thank you.
Thank you, Catherine.
Audrey, have I answered your question?
To some extent, it provides a little bit of clarity, and then also a whole string of other questions that I will have to mull my head around as well. but
Yeah,
I have to take it to the business, and then I'll just email. I think you said to Andrea to direct my questions at Mr. Nemasisi.
exactly.
Thank you so much.
Karabo?
Hi guys. Sorry, I just have two questions. One is mostly related to marketing, right? So the first question I have in regards to marketing is new versus old clients, and whether the how can I put it? Whether the guidance notes that will come out in regards to marketing apply to both the same. So when I say new versus old, I mean clients onboarded after the 1st of July and clients onboarded before the 1st of July. And this is in terms of the technical applications that we essentially have to apply to our marketing. The opt-in and versus opt-outs, marketing existing products versus marketing new products. Do we treat new clients and old clients the same? Or do clients onboarded after the 1st of July, does the application of POPIA differ?
Okay. Are any of my colleagues online?
We only have Advocate Stroom for now, Chair, on the line.
Advocate
Can you hear me?
Yeah, can you answer that question, please?
Can you hear me?
Yes,
Yes. The marketing one, but my line is still very bad, but I'll try to answer the marketing one. Thank you, Karabo, for the question. I think this is one of the questions that we will address in our guidance note, because we have debated this as members in terms of the list of people that you have prior POPIA and the people that you'll have in your marketing list after the 1st of July. Remember, after the 1st of July, it's opt-in. They have to be you have to get consent to have those people in your list. But the previous one, I don't have a definite answer, but our view, we're debating the view, but if you want the guidance note is that if you want to use previous people that you have on your list post 1st of July to 2021, you have to get their consent.
Okay.
It's like having a database. So you have to go individual to every person and ask for consent, but that's what POPIA said. You need consent of each and every person to have them on your list. But in our there are people who are coming to say, but a lot of database, what do we do post? But in terms of POPIA, you have to have consent. It's opt-in. So you have that's the debate that we had. We haven't had a formal view on the issue because it's been coming out. But I think the guidance note that we're going to do on direct marketing will help and assist in terms of how do we deal with information or databases that we had prior POPIA.
Okay.
I think maybe that covers you. We'll address that.
Thank you so much. Just one more thing. In regards to the marketing guidelines, and I'm just asking this in terms of, because I mean, I think everybody who's involved in direct marketing will then have to make arrangements. So if the guidelines notes comes after, or they get released after the 1st of July, and maybe there's we haven't complied, would that be a problem? Because I mean, we essentially, I'm not saying that we're relying on the guidance notes, but the guidance notes do help us with complying. So I'm just like thinking, what would the timeline be for those guidance notes? If you can answer that. If you can't, it's okay.
I think like guidance notes are what it is. It's a guidance note.
Yes.
It does not relieve anyone from complying. You have to comply.
Okay.
So you need to put that. We are just trying to assist, but make sure by the 1st of July you are compliant.
Okay, cool. Thank you so much. Thank you.
Thank you, Chair. We have Monde and Margaret, if they could ask their questions one after the other.
Sure, thank you. Just a follow-up, or just to go back, in fact, to Audrey's point, and I just need a bit of clarity. I'm not sure that was provided. I think we all understand the nature of the authorization that the chair was speaking about. But now, I mean, I think, wouldn't it be possible that the regulator, instead of us applying individually for these issues of having CEOs or MDs for multiple companies, can the regulator consider making a, I don't know, a ruling or some sort of a issue, some sort of a note or something to make it a rule instead of having to go through all these manual application? I mean, it may become burdensome for you guys at some point.
No, we can't, because the Act says that information officers must be registered with the information regulator before they perform the POPIA function, and we must keep a register. So we can't do otherwise, because we don't know, we won't know who the information officer of a particular private or public body is. They have to register, and it's important for that register to be there and to be published, so that if people need to contact the company either for POPIA functions or for POPIA, they must know who the information officer is. So unfortunately, we can't just make an assumption. People have to register and put their contact details so that private data subjects can be able to contact.
Noted. I mean, what I'm getting to is that if you've got multiple companies and the CEO, the MD is the same person, like now we're sitting with issues where the system only accepts one ID. Now I'm saying, in order to relieve, I don't know, to remove this problem, now instead of us having to apply for this person to be recognized for multiple entities, because in essence we're sitting with a situation where we've got an MD, but now there's no one to authorize to be sort of the second information officer per se. So in essence, we'll need to email your office for a manual approval per se. Now I was saying, to avoid this issue of manual approvals, can't, I don't know, be there some sort of a process or recognition that in essence you'll have CEOs or MDs that are information officers for multiple entities, so that become normalized rather than an exception. Yeah.
I mean, I said to you, when we created this guidance note, we created with what was in our minds at that time, that was one information officer for one entity. But we have now become aware of the challenges that some private and public bodies, private bodies are experiencing. So we'll have to go back, because if going back, we'll then have to look at the portal itself and make some adjustments in the portal, if at all we're going to allow one person to be the information officer for multiple entities, because at this point in time, the portal has been developed in such a way that they recognize just one person for one entity. But we'll have to look at that, because that will also mean adjusting the portal itself.
Thank you very much. I think I would appreciate if we could get, official communication from the regulator stating this fact. Yeah, so that we have something formal. Thank you.
Okay, thanks.
Margaret, and then followed by Arend Meyer.
Thank you very much. Good morning, Advocate Lakula and colleagues. It's Marguerite Jacobs from the Banking Association. Advocate, thank you so much for the presentation. Very insightful and appreciative of the opportunity for us to ask questions and seek clarity. I will just appreciate your guidance to understand the process that will be followed once a code of conduct has been submitted to the information regulator. The process internally within the regulator prior to it being published for public comment, and then also expectations after the public comment period has expired, what is expected of the sector in response to any comments received, etc. Thanks, Advocate.
Advocate Strom. Are you still on the line? I don't know if she's still on the line.
She is, but she's still muted.
Advocate Strom. Okay. I think what will happen, and because we have received about 2 or 3 applications for codes of conduct, of course we'll publish the comments, we publish the code of conduct, as you've said, in the Gazette, and then we ask for public comments. I think in line with fair administrative procedure, once a public comment, if a comment has been received, in my view, it has to be given to the applicant, to the responsible party who has applied for a code for their observation. Because I don't think we can just receive comments and then deal with them without reference to the applicant. And then thereafter, we will then look at what has come from the applicant, in terms of those comments, and we'll then be making our own decision based on comments that will have come from both sides before we decide to issue.
Thank you.
Thanks.
Thank you, Chair. We have Arend and Nico, if they could, those are the last two hands, and then I'll just read a few questions from the chat group.
Okay.
Good morning. Thank you for the opportunity. I'd just like to know I just have two answers, two questions, sorry. I have a retail company.
It will be nice to have answers, you know, Nico. It will be very nice to have answers instead of questions.
We have a manufacturing company, and we keep the personal details to give a guarantee on a product. If I can't keep a sales history of a client, how am I going to give a guarantee, and how does that affect with the Consumer Act? And my second question will be, what do I need to keep in store to be compliant? If an officer comes in to see if we're compliant, what do I need to give them and show them for our compliance? Thank you.
Advocate Strom, are you here?
Yes, can you hear me now?
Yeah, can you take those questions, please?
Yeah, it's not very clear. And the question you own a retail company details of your clients.
Sorry, you're breaking up very badly.
Sales history. I think this is very bad. I don't know.
Okay, I think
me now.
Okay, yeah, continue. Try.
Let me try. Can you hear me now?
Yes, continue. Okay, you know, I didn't quite get, you said that you have to give, what is the gist of your question regarding the first one?
I do custom manufacturing work for the public, and if they ever have a query or something went wrong and they want to bring it back for a guarantee, then I need to have a record of work that I've done for them so that I can follow through and give them assistance in that matter. If I can't keep records of them, how am I going to, especially with valuations and things like that as well? If things go missing or if they have loss of product, then I need to give them a valuation of work that they have had done with us before.
Yeah, but do you keep the record of their personal information? Do you link it, do you share and link it with other people, with other companies?
No, that will be just in my company alone.
Oh, okay. No, you have to, I mean, you can keep the record. There's nothing that says you can't.
As long as I don't share, it's fine.
You can't share without their what is it? Without their consent. You must use it only for the purpose for which they've given you that personal information. You can't use it for anything else. You know, because if you keep it and then you decide to sell it or to do, then you're in trouble. So you just need to look at those 8 conditions and make sure that you comply with them and secure that information as well. So that
wonderful. And what do we keep in store for a compliant officer if they were to visit our store?
No, I think I can't answer that question, because if I will be giving you legal advice, you need to go to the people, because we can come and do an assessment to check your compliance. So I can't advise you on what you need to keep. You need to go to people who provide the service, and they must advise you. You know, we also have to ensure that we don't enter ourselves into a situation where there will be a conflict of interest, where we give you legal advice to say, do this, 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 and that. When we now have a complaint against you, we can't adjudicate that complaint, because you'll say, no, but you, information regulator, you said I must do this, this, and the other. So you really have to go and find people who will assist you with your compliance processes.
Okay, thank you.
Nico, and then the last person will be Yashwin, and then we'll close the question and answer, and then I'll just read out a few questions from the chat group. So we'll allow Nico, followed by Yashwin. Thank you, Chair.
Nico, not Nico. Nico.
Nico.
Okay.
Thank you very much for that. And thank you for the opportunity to seek some clarity. My question just relates to the process for issuing codes of conduct. Where a body wishes to make application to have a code of conduct issued, would a company be included under that term of a body? And if so, what does it mean to be sufficiently representative? Is there any guideline as to what that would constitute? Or is it just limited to, for example, an industry association that can make such an application? Thank you.
I'm not sure whether I haven't looked at the regulation of late, because we did the regulation. I don't know whether we have not defined sufficiently represented. We'll have to go back and check that. Something says to me, maybe in the regulation, that regulation number 5 on codes of conduct, we might have looked at the meaning of sufficient representation. The first question I didn't quite get.
The first question related to whether a body includes a company. Say, for example, a company operates in a particular industry. Would that company be able to, on its own, bring a code of conduct to be issued for that industry?
I think if you look at section 60, it's very clear on who can apply. I don't think a responsible party on their own can apply, because it says it has to be a specified body or class of bodies. And then it talks about a specified industry or profession or vocation. So we have looked at this quite carefully, and says what is a body, what is a class of body. And we when we debated, we said, look, if you look at the trade union, a trade union will be a body. And then COSATU, excuse me for giving that, will be a class of bodies, I think. So I think that's how we see it. Are you saying as a company on your own, can you apply for a code of conduct? If that's your question, I don't think so. Unless you have to belong to an industry. That is why there is the issue of sufficient representation, because you either have to be a professional body, you have to be an industry, you have to be BASA, for instance, and so on. BASA is the Banking Association.
Okay, I see. So an industry association, for example, but not a company within that particular industry. More so an association, or as you say, a trade union.
Yeah. I mean, the question that arises will then be out of, what if you are not part of that association? I think issues of freedom of association come into being, because you cannot be bound, in our view, by a code of conduct adopted by an association which you are not part of, which means you won't be bound by. But these are all issues that we've said these issues are up in the air because we have done these guidelines, the guidance notes. The problems will come, or the gaps, or the anomalies, or the ambiguities will surface when we start to implement. That's only when we'll see the gaps and what we need to fix. For now, we're talking theoretically, but once we start implementing these things, like with the issue of the registration of information officers, there were things that we did not anticipate when we drafted the guidance note, but these issues are now surfacing. So as we go, we'll then have to fix and align. As long as we are all mindful of that and we become patient with each other, because it's a learning curve for South Africa.
Thank you for that. And
that is my final word, to say that that's what we need to look at, because we're learning on the go. I mean, the GDPR, there are even in the GDPR things that are not settled up to date, even if they've been at it for a couple of years. Yeshwin, your question.
Thank you, Chair, for the opportunity. My question is just short. With the contact details provided on the chat box, can we use those details as well to address issues with the regulator in terms of interpretational issues, or issues that we need guidance when it comes with issues related to conflict with the POPIA and other legislations? So are those emails available for queries regarding those types of issues as well? The emails provided by Nomzamo on the chat box. Thank you, Chair.
Nomzamo, answer for yourself.
Yeshwin. Yes, Yeshwin, I've shared 3 email addresses on the chat group. One was for Mr. Nemasisi, particularly on the issues that were unique, that were the queries that came through with regards to the registration of information officers. I also shared our general inquiry email address, which is the inforeg@justice.gov.za, which is where you can send the emails with regards to the particular or specific information you'd require guidance on. So that's the one you can use. But in relation to stakeholder engagement and any queries that you also still may have, you still can also share it or CC me on my email address that I have shared, which is nozondi@justice.gov.za. So yes, Yashwin, our line for general inquiries is inforeg@justice.gov.za.
But Nomzamo, I think for specific questions relating to codes of conduct, you need to put Ms. Sulal's number, email address. If it's specific to codes of conduct, is Ms. Vasha Sulal. Questions relating thereto must be sent to her.
Okay, Chair, we will share Mr. Sulal's email address for specifically codes of conduct. Thank you, Chair.
I think we are about to conclude, and yes. in conclusion, as I have said, I mean, there isn't, I can't stress this enough, that we are partners, we need to work together. We are implementing a piece of legislation that has never been implemented in this country. We are all putting our best foot forward as the regulator under quite difficult circumstances. We work 24 hours, all of us. So we depend on you to work with us. If there are issues, I mean, that you don't understand, if there are contradictions in our processes, anomalies and so on, as I've indicated, please bring these to our attention, because those can only enrich our processes and make our processes better. So as we march towards the 1st of July 2021, which is a very historic day in the history of this country, I think, and in the history of the realization of the right to privacy as it relates to protection of personal information. We should all bear that in mind, that together we are creating history. Thank you very much. for your attention. Nomzamo, over to you.
Thank you very much, Chair. We will definitely look at the questions that were posed and raised in the chat group, and we will respond to them and share it with all the stakeholders that was actually online, because we do have your email addresses as per your registration to this platform. And we are also sharing some salient issues that have been presented today on our social media pages. But then again, please feel free to email us if we're not able to cover all your queries on this platform. We are embarking on having more webinars in the coming months. Look out for the invitations on our social media as well as our website. But thank you so much again for your participation. Thank you, Chair.
Thank you very much, and wishing everyone a happy Africa Day. Thank you, and the meeting is adjourned. Thanks.